to discuss how corruption fuels insecurity and bad governance, the role of lawyers in tackling corrupt practice in Nigeria. Without much ado, we'll go straight to the point, and it's my pleasure to invite the moderator, Professor Joy Ezilo OON, United Nations Special Rapporteur and Dean Emeritus, Faculty of Law, University of Nigeria, and former United Nations Special Rapporteur on Trafficking in Persons, especially women and children. Professor Ezilo holds a PhD from the University of Nigeria, an LLM from the University of London, and an LLB from the University of Nigeria. She also holds a diploma in peace and conflict resolution. Professor Ezilo is the 2019 winner of the National Human Rights Award and was also honored on the 5th of March 2022 with the Civil Society Award for Excellence by the United Nations Development Programme, UNDP, and the UN Women in collaboration with the embassies of the United States of America, Germany, France, EU delegation, and the British High Commission in commemoration of the International Women's Day Gala held at the United States Consul General Residence in Lagos. We're delighted to welcome Professor Joy Ezilo. A round of applause, please. May I also respectfully invite the chairman of the Independent Corrupt Practices and Other Related Offenses Commission, Professor Bolaji Owasanoye, Senior Advocate of Nigeria. Professor Owasanoye is the chairman of the Independent Corrupt Practices and Other Related Offenses Commission, the first and pioneer anti-corruption integrity institution in Nigeria. He is a Taslim Elias Distinguished Professor of Law at the Nigerian Institute of Advanced Legal Studies and a fellow of the Chartered Institute of Arbitrators of Nigeria. Professor Owasanoye holds his bachelor's degree in law from the University of Ife, master's of law from the University of Lagos, and certificate in legislative drafting from the Royal Institute of Public Administration, UK, and the Nigerian Institute of Advanced Legal Studies. He has consulted for the United Nations Institute for Training and Research, UNICEF, DFID, USAID, and the World Bank. Together with also other CSOs, he is the co-founder of the Human Development Initiative that works with CSOs to stop impunity. And they lead the Impunity Nigeria campaign on eliminating impunity in public finance management. A round of applause as we welcome again Professor Bolaji Owasanoye. It's also my pleasure to welcome Mr. Martin Ejidike. Mr. Ejidike is the Chief of Office of Genocide Prevention and Responsibility to Protect DPPA, United Nations Department of Political and Peacebuilding Affairs, New York, USA. He holds a Master's of Law from the University of Nottingham, a Doctorate of Philosophy from the University of Vienna, and a Master's of Science in International Affairs from the University of Nigeria and Nsukka. A round of applause as we welcome Professor Mr. Martin Ejidike. Joining us virtually are two of our esteemed speakers, Dr. Sam Amadi. Dr. Sam Amadi is a policy strategist, law and governance expert, director, Abuja School of Social and Political Thoughts, and is a visiting professor at the Emerald Energy Institute at the University of Port Harcourt. He is the chair of the Development Law Group of the Nigerian Bar Association Section on Public Interest, of which he is also a founding council member. He is an associate professor and head of the Department of International Law and Jurisprudence at Bayes University, and he held that position until June 2021. Dr. Amadi is a peace and conflict management and justice sector professional and has delivered and commissioned papers for Nigerian Institute of Peace and Conflict Resolution. He has engaged in conflict mitigation from the United States Agency for International Development and has worked with restive states in northern Nigeria and Niger Delta. A round of applause as we welcome virtually Dr. Sam Amadi. Last but not the least is Mr. Olarenwaju Suraju. Mr. Suraju is the chairman, Civil Society Network Against Corruption. A round of applause as we welcome Mr. Olanrewaju Suraju. Our day is fast spent and we'd like to go to the crux of the issue. And at this point, it's my distinct pleasure to hand over the mic to our moderator, Professor Joy Ezilo, to take it from here. Once again, you're welcome.
Thank you so much, the moderator, distinguished colleagues, learned friends, and guests. I would like to first invite, please come to this side of the table, Abiye Tam George, who is the chair of the body of vice chairpersons of the Human Rights Committee of various, NBA across states. Please join us. We need to make this side of the hall gender sensitive. And we are looking for, where is the chair of the Human Rights Institute? Mr. Chinoyo Biago, SAN. We need you over here now. You have to give us opening remark. This is the event you're hosting on behalf of MBA. We're all set to go. This is afternoon. We know Lagos. Some people are trying to head out and get to their various hotels without being in traffic. And many are joining or have joined virtually. And that is important, so because we are going to be having big conversation this afternoon on the topic of how corruption fuels insecurity and bad governance, the role of lawyers in tackling corrupt practices in Nigeria. You will agree with me that this is a very critical discussion, particularly in terms of having sustainable development and democracy, and ensuring that human rights is respected in law and in fact. We will, in this discussion, look, and we have really, and I want to welcome the lead resource person, Dr. Sam Amadi, who is joining us virtually. And Dr. Sam Amadi, get ready, and I believe the IT people have tested their mic. Is he perfect? Good. Because he will be the first to go. I would like, even, of course, to interject later, but knowing how network, even though it's been so good, I've joined some of the sessions virtually. We have a very good connection with the MBA IT people. But we want to go on and also take those who are joining virtually. And besides, he is the lead speaker, and his speech will form the think piece for all of this discussion to go on. When you look at the topic we are looking at, you see it's like almost 3 or 4 in one. We will be looking at corruption, but importantly, how corruption fuels insecurity and bad governance. And then also looking at the nexus to human rights. And for us, or for me, I could postulate that corruption is both a cause and a consequence of human rights violation. And I know that the Executive Secretary, National Human Rights Commission, you are a very good student. Look at the way you are listening. Please come to this part of the table now so that you can be able to take some questions. We invite you. Please come and join. Welcome Mr. Tony Ojukwu, SAN, the Executive Secretary of National Human Rights Institute. This discussion will not be complete without him, and he needs to be on this part of the table to also make contribution towards this. So we will be looking, and we have the Professor Wasa, who is from Anti-Corruption Agency, one of them, and a leading expert already in this field, and who has done a lot of development work, who can easily relate to that. We have also an expert from the United Nations, Dr. Martin Ejidike, who can look at the human rights aspect as well as the current international regimes on this and the extent of compliance by nation states, including Nigeria. The human rights corruption nexus is a very important one. The human rights or the corruption's insecurity nexus is also an important one, because when we talk of insecurity, we're also looking at human insecurity as well. So I really hope that we get all the speakers speak, and we're going to have enough time, at least 30 minutes devoted to Q&A, and then finally they will come back to us in terms of wrapping up and statement. But importantly, we will want, because remember the question, the role of lawyers, at the end of the day, to look at possible solutions and also direct moving forward what MBA as a body should do, or what they are doing and whether it's in order, and what they should be doing to make sure that as we fight to tackle the insecurity and the hydra-headed monster of corruption in Nigeria. So it is my pleasure also at the very beginning to invite the chair and the pioneer chair of the Human Rights Institute in the person of Mr. Chinonye Obiagu, SAN, who is a well-known international human rights activist, to give also a welcome opening remarks. I know I don't know whether I did inform you, but it would be nice to hear from you. And then from there, we can invite Dr. Sam Amadi to speak. Welcome, Mr. Chinonye Obiagu, SAN.
Thank you, Professor Joy Ezilo. Leonard Brother Silk, I don't know if my Lord is here, Leonard Brother Silk, ladies and gentlemen, it is my pleasure on behalf of the Council of the Human Rights Institute of the Nigerian Bar Association, to welcome us all to this session holding in Hall B of the conference venue. The theme of the topic has been carefully chosen because it's apt with the theme of the conference, the bold transition. We cannot transit boldly to a better Nigeria without talking about the fight against corruption. And I'm glad that a number of lawyers have taken interest in this topic, both physically and visually. I must conclude by introducing the Human Rights Institute. The Human Rights Institute of NBA was created under the leadership of Ms. Olisa Bakoba many years ago, but it has not really taken off. So the regime of Olumide Agbata in March this year inaugurated a new council and dedicated a building, the old NBA headquarters for the institute. So the institute is now well positioned to carry out sustainable program, capacity program for lawyers. And we are, of course, in partnership with the body of vice chairmen of the branches, who are in their branches the chairman of the Human Rights Committee. So it's a robust body that promises to carry out the mandate of NBA, which is promoting the rule of law. So the forms for membership to subscribe into the institute is available, to be shared by the ushers and also on our website. So on that note, I want to thank you all for coming and most gratefully thank the resource persons who have traveled far and wide to come to this session. Thank you very much.
Thank you so much. So we are going to go on right away and invite Sam Amadi, who has been introduced, and I tell you he has a very long bio. But importantly, I like when we have this sort of discussion to have people who have been active in civil society, but beyond being active in civil society has had abundant opportunity to serve in the government, in executives capacity, and in the public sector. And with Dr. Sam Amadi, we have all of that wrapped. He's a scholar, former scholar, activist with a very long and excellent CV, and we're amongst which is when you have PhD from Harvard and Harvard Law School, we know that you're distinguished. So he's coming from that background, and we really, he would have loved to be with us here, but is unavoidably absent and joining by Zoom. Dr. Sam Amadi, you have the floor. Thank you.
Thank you very much, Professor Ezilo. I call you my man. So we come a long way, and I'm happy I'm moderating this event. First, let me say that I have 15 minutes, but I want to do 12 minutes or 10 to 12 minutes because of traffic situation, so that I will allow others to finish. We're looking at human rights, good governance, and corruption, of course, insecurity. So I would like to look at the nexus, but more or less look at how human rights approach would help more effectiveness in corruption and also help in stabilizing, ensuring security. First, I would like to start by saying that, of course, there are many human rights experts, so I'm going to go into definition and into process. But to make a few statements about human rights, first is that because we are now living in a juridical order that has mainstreamed human rights as valid legal claims, whether at domestic or international forums or fora, we seem to lose out or lose the fact that human rights human rights are essentially a moral and social order. So what that means is that today, from 1945 to date, we've seen an international and domestic juridical order built around human rights, legalization of human rights, starting from the Charter to the declarations, to the Geneva Conventions, and all the illustrations and amendments, and today to regionalization, where not just the international law itself is defined by human rights, but also regional framework are defined or mainstream, human rights are mainstream. And then we've come down to constitutionalization, where human rights are now a matter of constitutional law and constitutional obligation. So in every sense of the word, we are living in a human rights age, in an age where we move from natural rights, moral rights, to human rights that are fully legal rights enforceable both domestically and internationally. But what happens is that we tend to forget that human rights are primarily or essentially moral rights, and therefore they require and stipulate a certain moral order defined by some considerations about human beings, and also require a social order. And that'll be important when we look at the issue of corruption. So in the Nigerian case, of course, the debate around or the structure around civil political rights and social economic rights got early institutionalization in the Nigerian legal system, from 1960, with the Bill of Rights. Nigeria was the first country in Africa, in Commonwealth Africa actually, to have a human rights provision embedded in the Constitution as Bill of Rights. The immediate history of that was also the question around how to structure post-independence Nigeria, dealing with the fear of minority over majoritarian control and dominance. And so, just like the Americans, Nigeria adopted a counter-majoritarian device, one of which is, of course, a written constitution, a Supreme Court that has judicial power, but more importantly, fundamental human rights that guarantee basic human rights to all Nigerians, irrespective of political affiliation, authority, or power, and irrespective of number. Then we move forward with the African Charter and the domestication of this provision by the Supreme Court. But then, the human rights, because of their moral character and social order, are critical conditions for democracy, good governance, and an anti-corruption regime. So the point I would like to make is first that having established a rich human rights regime, we now have the framework to enthrone a democratic society and one that has high level of probity. But the big question is, once again, to look at the relationship between human rights and corruption. Right? Now, I argue in my paper that there are two approaches globally for dealing with corruption. One is what I call the eradication approach, and of course, the integrity building approach. What we've done mostly is the eradication approach, and we've taken the form of that focus so much on law and strict and harsher rules. Now, that approach results in what we call legalism. That is a notion that the answer to problem is small laws, better laws, and harsher punishment. Many of our people talk around death penalty for corrupt persons, special tribunals, and order. Now, the problem is that the eradication approach wrongly focuses on symptoms rather than the underlying cause. The integrity building approach focuses on underlying pathologies. And that's the approach that mainstreams human rights, because it deals with, first, dealing with the norms that define collective action, norms of accountability, respect, equality, and liberty. They also feed into this structure of institutions that protect these norms. Institutions, free speech, institutions of competitive elections, fair and fair elections are competitive, institutions of oversight, institutions of freedom of information bill and regime of access to information, regimes around whistleblowers and protection for them, regimes around accountability. So when you focus on the human rights oriented approach, you will focus mostly on ensuring that these norms characterize a social order. And then these norms constrain excess of power and empower people to bring to account through open systems and through effective, whether it's prosecution or effective articulation of those rights that enable society to move from feudal, patriarchal, patrimonial states to modern, open, liberal, and democratic society. And so what scholars have found out is that movement from what we call Denmark, rhetorically for clean society, to move to Denmark is not just about engrafting new laws. It's actually about opening up your system to these norms of equality, these norms of openness. Because when equality is enshrined and liberty, then office holders can make the distinction between public and private. So one of the problems of corruption in Nigeria is that in spite of our laws, the overriding governing ethics of governance and leadership in Nigeria is still feudal or neo-feudal, to the sense that leaders see themselves as entitled, and they can't distinguish between the private and the public, which is at the heart of anti-corruption society regimes. And therefore, while we focus on laws and maybe trials and prosecution, we're not focusing on entrenching a social compact that's underlined by the morality of human rights, which is a morality that first accepts equality, liberty, openness, and therefore accountability. Now, if you bring it to the security aspect, well, I want to lay out an overarching so that others can pitch in and expand. I do argue, people argue that all societies in the world are corrupt to an extent, but I argue that apart from the fact of corruption, the nature of corruption is critical to whether corruption becomes extremely dangerous. So people have argued that in China, in Singapore, and Indonesia, all these countries that are Taiwan, that are doing well economically and moving from third world to second to first world, they have corruption. But the difference is, and Robert Wade, in his book on economic development, late industrialization, argue very well that the difference between corruption in India and corruption in some of these other countries is that in those countries, corruption may result in small inflation of price of dealing with good quality products, roads. But in our own country, corruption means that those roads will not be built. So there's a difference between corruption that results in inflating prices for standard roads and corruption that involves totally not building the road or building substandard roads. What this means, therefore, that the character of the state and its relationship between the elites and the people determines the nature of the corruption. So we're fighting corruption. We talk about grand corruption, petty corruption. But the real character is the corruption of Nigeria is a corruption that involves eroding the effectiveness of state. And that's where insecurity comes in. Because insecurity, therefore, in Nigeria is driven by corruption that involves hollowing out the essence of state, the values that underline an effective state. And that's why we're hearing recently about soldiers who connect with terrorists or soldiers who share money that is, ransom money. So the state has collapsed because corruption has eroded the norms that define state autonomy and state effectiveness. And therefore, the Nigerian state is no longer autonomous of the interests, the special interests that drive it. And therefore, the Nigerian civil service and the bureaucracy has no independence to enforce the autonomy of the state and therefore the protection of the state. So going forward, what can lawyers do? So let me wrap up by looking at this, bringing these three strands together and what lawyers do. First, lawyers themselves and the law, the rule of law is not as important as the rule of law. The role of law is what does law do in a society. A country that wants to be less corrupt has to allow law to create an egalitarian structure. And that's where the issues around the socioeconomic rights are important. If you have high inequality, if you have a feudal state that gives a lot of prebendalism, a lot of prerogative to the rulers, and that dehumanizes the ruled, then you're going to have a society that will be both corrupt in essence and insecure. And so law must first focus on removing inequality and creating accountable society by transforming relationship between citizens and leaders, by creating more framework for accountability. Once you do that, you will be able to erode the neo-feudal norms that condition to corruption. Secondly, high level of accountability. Today, we should have some laws. The Legal Practitioners Act should be amended to place an obligation and accountability on lawyers who advise government wrongly. Today, it's risk-free to advise government on corruption, to be part of compounding procurement policy. Lawyers suffer nothing. But like we say in policy, if you have a skin in the game, there should be new rules that place obligations and disability and punishments for lawyers who help in creating outcomes that are corrupt. Many of these corruption transactions are either advised or helped by lawyers. So at the level of lawyers' responsibility, we have to begin to indemnify legal advice that fits into these corrupt practices. And third, very important, is that I think there's a time now for a strong section or a strong commission or group or committee that focuses on public sector corruption involving lawyers and public servants. The real driver of corruption in Nigeria is not all these political exposed persons who steal money. It's actually the bureaucracy that backstops the lack of transparency, accountability, and openness in government. And therefore, the NBA should do strategic work in both opening society to greater accountability. Freedom of information requested by people like Suraj should be a routine matter of law. And therefore, executive orders and rules. I've argued for long for the Administrative Procedure Act equivalent like in the US and Nigeria. What that does is that we are moving to a highly regulated economy. And regulators don't have accountability. Some of their laws don't expose them to high level of accountability. Thank you very much.
Thank you so much. Please, round of applause. He has really brilliantly set the stage for the discussion, especially looking not just at the legal issues around the topic, but you can see the way the interconnectedness or interrelatedness of the issues, how he brought out the human rights, the insecurity and corruption nexus. And then looking at philosophical issues as well, and the impact of morality on the law and our approach of eradication or legalistic or approach to combating and to combat corruption. Take a step back. Thank you. I think we'll come back to you, please. And A will come back to you. We will like Olarewaju Suraji is online. Please hold on. We will come back to this, those who are physically attending. so that we can take Professor Owasanya. Professor Owasanya is the chairman of the ICPC, Independent Corrupt Practices Commission. He's a professor of law, distinguished professor of law. He's a senior advocate of Nigeria. And he was, before his appointment as chairman of ICPC, the executive secretary of, that is, Presidential Advisory Committee Against Corruption. So he's one of us in the legal community, and he's doing this work. And I believe now we've come to the panelist. He can give us his perspective, as well as feel free to interrogate or to engage with some of the positions or statement from Dr. Sam Amadi. Prof, are you going to take the stage? I think it's better. Thank you.
Thank you very much, moderator. And good afternoon, Sam, remotely. I will go straight.
Thank you, Prof.
I'll go straight into the meat of my conversation, and I'm going to start by challenging some of your positions. The first is on a focus only on eradication or enforcement, which I take to mean, you mean that we focus only on law and order. You are right that that predominantly is the case, but ICPC is focused also on behavioral change and changes in the process as part of our prevention mandate. So, for example, we have specific projects that are designed not just to focus on law and order or eradication, which is much more time intensive, much more costly, but helps to prevent the malady from happening. So, for example, every year after the budget, we take the budget and unpack it. Even before people start, the various agencies start implementing, or even while they are implementing. And in the process, we see a lot of anomalies, for example, duplication of projects and stuff like that. And we prevent the money allocated to those projects from being released. As opposed to looking at the budget at the end of the day, the money has been released, has been spent, and part of the money will be used to challenge you in court, and you are not likely to get the money back. So we stop that from, that's just one example. I could give you a few more examples. Second quick point, before I go to my own notes, the notion of more and more laws. Again, you have to take it in context. New laws are made, one, because of pushback by important constituencies who refuse to accept or align with international best practices. And those things affect Nigeria as a country, diminish our ratings in international measurement indicators. And I'm going to give two examples. So, for example, a new money laundering statute was passed this year. And one of the reasons for that is because of the resistance of institutions within the country, including, for example, the legal profession, who didn't want to be accountable for any defect or default in their own professional practices that fuel money laundering. And so we went to court as an association and got a judgment that says attorney-client confidentiality and so on and so forth. That's fine. We're not the only ones who have that. But you have to take it in context where a crime has been committed. If you're an officer in the temple of justice, you must support. Now, one of the things that happens is that weaknesses in our practices and in the laws then make international rating agencies like FATF. So once the country is poorly rated, you can be decertified. If you get decertified and you are borrowing, you borrow at a higher rate. So Nigeria, as we know, is borrowing a lot of money right now. Because of gaps in the legal framework, because of the observation that, the courts are resistant to some changes, the legal profession is resistant to some changes, the financial services sector does not do some things. Nigeria borrows at a higher rate, and you can check this out. So whereas another African country will borrow at like 3 or 4%, Nigeria will borrow at 12% from the same market. So sometimes the need for new laws is driven by, I give another example, poker. Poker has just been passed, the Proceeds of Crime Bill Act, signed by the president about 2 or 3 months ago. Why did we have to have poker? Because in other countries where there is no statute for civil forfeiture, the rules allow the principles of law. Sometimes, in Nigeria, the constitution even recognizes civil forfeiture. And yet some people will resist it until the statute had to make things very clear. And the new Money Laundering Act, as I mentioned in my presentation, now abolishes legal and professional privileges and client confidentiality with regard to certain specific things that are inimical to the stability of the state. Now, the whole conversation we're here to have is how corruption fuels insecurity and bad governance, and what role can lawyers play. I'm not going to go into the background. All of us know that corruption impacts development. When you divert the public budget, either on the expenditure side or the revenue side, which are both very critical, when you loot the treasury, which is what is most apparent to most Nigerians, but there are many other anomalies that are not very apparent, like illicit financial flows, subtle tax evasion, the misapplication of funds, budget parting, the proliferation of ghost workers that takes away revenue, the deliberate introduction of elephant projects, which are either not done or abandoned, etc., etc. We all know that once you continue to allow these kinds of things, something is suffering. The money that ASU wants has disappeared into unnecessary projects, has disappeared into budget padding, has disappeared into paying quote and unquote ghost workers. The summary is that the state will be incapable of providing services that bring stability. And when we are talking about security or insecurity, it's not about army and all that. It's about the welfare of the people. So people have health, there's education, you can work and get your salary, you can earn your pension, you can travel from point A to point B, you're well secured. That's the real security, not necessarily the size of the army, the armament, and what have you. The immediate casualty of this sort of corruption in government and governance is health, education, housing, food, basic infrastructure, etc. Those are the things suffering. So you find that it's taken how many years to build Lagos to Ibadan Expressway? But every year, there are thousands of phantom projects in the budget. Projects that are not done or have done or abandoned, 3/4 of the money is stolen. If you don't block those loopholes, we will keep looking for the money to build the roads and to build railway and all that. So, how quickly will this sort of corruption, whether pervasive, retail, or grand corruption, how quickly will it show? It depends. If the money is being stolen in small bites, it will take a little while before it has an impact. If the money is stolen in a big chunk, the country will feel it in 1 year. But both are bad. Whether it is retail, small bites at the budget is X trillion, you steal 500 billion. If the budget is 10 trillion and you steal 500 billion, people may not notice, or below. If the budget is 10 trillion and this sort of systemic corruption diverts, the budget now takes about 70% on salaries. Part of what ICPC does is to look at who is getting the salary. Because within that 70% for salary and overheads and all that, you still have these anomalies. Then you have 30% for capital projects, which are supposed to be the ones that catalyze development, but also suffering from the malady of corruption.
Leonard SN.
I'm going to round up in 2 minutes. So, what role for lawyers? Very quickly. I think lawyers, we seem to be suffering from ethical fault lines. In ICPC, we get letters from lawyers purportedly acting for clients. my client, so, a public servant who is doing her business or his business, got a contract. Your client is a public servant. That's a lawyer writing. A public servant who is not supposed to be doing business and got a business, and there's a problem with somebody else. This is a lawyer writing us and soliciting our assistance to come and help claim for a client who is already in the wrong. One example. 2 examples. Our client also was approached by Chief Tony Ojukwu, not you, another Tony Ojukwu, to say there is job in Human Rights Commission. Our client paid 2 million, and Tony did not deliver the job, and they want us to help them. These letters are written by lawyers, members of NBA. So I'm asking myself, is there an ethical fault line? In other words, have lawyers lost a sense of understanding of what is wrong and what is right? To the extent that you take and then when we pressure them, they run to NBA and say law enforcement is harassing lawyers and preventing lawyers from doing their work. Which work are you doing? If you write those kinds of letters. We have one case which I wanted to cite, how lawyers facilitate as middlemen money laundering. Very, very heavily, and we have been implicated globally. And one of the reasons the Money Laundering Act was amended, as I said, is because of pushback. It's because of pushback. The society will always respond when professional bodies act unethically. Society is uncomfortable. And when they are uncomfortable, they make more laws, which sometimes we will then say, oh, there are too many laws. But that's the way society responds to some of these challenges. And so, because we have a case in which a lawyer, purportedly acting for a client, had the stolen money paid into his account, and through his account distributed the money all over the place. So we arrested him. He ran to NBA, including to the current president. And I said to the president, did he tell you what he did? We have since got a judgment against him, with the court emphasizing that he is a crook and a criminal. Now, when lawyers play these sort of roles, you begin to ask yourself, do we have an ethical fault line or a dysfunction? I close by looking at the judiciary as well. The courts are virtually in the same mold. The courts resist intervention and interrogation of their processes and their practices. They want to gratuitously strike out provisions of anti-corruption laws that are supposed to stabilize the society and help get this development that we're talking about. And sometimes the lawyers who push for this thing are very proud of themselves. They are very, very proud of their achievement. The courts give orders saying that an anti-corruption and a law enforcement agency cannot investigate, cannot arrest, cannot prosecute. You give such a blanket order. So I'm asking myself, is there also an ethical fault line with the courts? If law enforcement are no longer able to do that, you don't need them. You better scrap them at the end of the day. So how do I close? What is the NBA doing? I think the challenges under focus are not new. They have been with us. What has the NBA done? Read my lips. Nothing. What is the NBA going to do? Hopefully, with this concept of bold transition, I'm hoping that we can transit from timidity and inertia to actively. And the strongest symbol and signal of inaction is to look at the disciplinary committee and the process. It's not rocket science. Just take a stock 1 year. How many cases have been treated? And the biggest culprits are not the rank and file lawyers. They are the senior lawyers. And if we don't start from there, we're only deceiving ourselves. Next year, we'll have another session like this. But don't call me.
Wow. Wow. Thank you. Thank you. Thank you so much, Professor Bolaji Owasanya, SAN. Please, another round of applause. Please note your question because we are going to come back to him and others. He has really challenged us, especially the legal profession, in terms of our action that are unethical in representing clients, including actions that amount to corrupt practices. And these are very serious issues, and I hope hereinafter we can even we need urgently even a session with your commission and sister agencies. We'll go right away to Soraji. I think he's online, please. Do you people have him online? Olariwaju Soraji?
Yes, I am.
Oh,
If you
good.
can hear me, I
Please,
am.
please, you have 5 minutes.
I will try to be disciplined and not to corrupt the timing.
Okay, thank you
Thank
so
you very
much.
much,
You've been
Prof.
on the line waiting for
Yeah.
us. Thank you so much and for the work you do.
It's my pleasure. I have a great opportunity of having to address this gathering again after that of last year, and also the same very topical issue. And I want to give that kudos to the current leadership of the NBA for putting this issue about corruption and also the role of the legal profession in the front burner. I think it is something that is really concerning, and also moving from the position of. Hello, can you hear me? Hello?
Please,
Hello?
we can hear you. What will happen is that maybe they should, I'm sure they muted already those who are not. Please go ahead.
Okay.
We can hear you clearly.
Okay, all right. Okay, then, thank you. So starting from where Professor Owasoye actually just landed, and I think the first one is for there to be the bold transition. We've had that bold emergence of the current president that is actually leaving office and transiting with the reform that happened in the NBA, where you don't have the senior advocate that were the traditionally president of the association. And that, I think, that emergence should also be taken forward to see how we change the current tradition of where you have particularly the legal practitioners disciplinary committee that is actually populated by those that you can actually successfully even accused of being involved in the practices that are unethical within the legal profession. And you've had a situation where even the chairman of the legal practitioners disciplinary committee was accused of even tampering with evidence and also witnesses. And that person sits as the chair of the legal practitioners disciplinary committee. We've just seen also the situation where the chairman of the body of benchers was accused of also unprofessionally meddling with the process of some client of the other senior lawyers within the profession. And these are the unethical practices that has already started moving from the trend where you've had it, with the public and creeping his way into the professional association. And this is the best time that we can have the bold movement, the bold action, the bold also decision by not just the leadership of the NBA, but by the entirety members of the legal profession, where we have to say no to this attempt by the senior lawyers to not only conscript the association and the profession to support their bidding. I was a member of the NJC Corruption and Financial Crimes Committee monitoring of the NJC of corruption and financial crimes cases. And my first concern with the membership, openly there, and I challenged them, that quite a number of the members of the committee were senior lawyers who are always in the habit or the profession or the services of the corrupt. And this will give them an opportunity for them to also not only intimidate the the judges, but take advantage of their membership of that board. And my immediate position was for them to actually recuse themselves from either that committee or even prosecuting some of the financial crime cases in court, because I can't see how in good moral standing, you're going to be monitoring the judges who would be handling cases that you are also going to be appearing before them. Unfortunately, I was expecting also the NBA to raise that critical issue and ask some of those lawyers to move away from there. And the trend is such that many of the corrupt rely on the lawyers, and particularly the senior lawyers. So you can actually count on your fingertips some of the senior lawyers that are usually employed for the services of defending those who are accused of corrupt practices within the system. There are not more than, I can say, 10 or 15 of them within the legal profession. And what that says is simply that they are technically in the habit of not defending the rule of law, of not defending the society, of not upholding also the egalitarian society that Professor Sam Amadi spoke earlier about. But it's about exploring the technicalities of the law. And after a while, they start calling for the amendment of the law. But the problem is not usually about the amendment of the law. It's about the fidelity of the lawyers and also officers at the Temple of Justice to actually defend the provisions of the law. And what that has done with the legal profession and the MBA is that it has succeeded in corrupting, also allowing the corruption of the judicial officers, allowing the corruption of even the judges, because there's no more monitoring. It is to the extent that lawyers are even victimized, abused by ordinary clerks in the court. And this is allowed to continue and also to grow within the system with an helpless situation of our legal profession and lawyers who are supposed to be respected within the society. I mean, lawyers are not even respected within themselves, much less in the society. And that is why you have some of the degrading description given to some of the lawyers within the country. And I think that the NBA at this time, and also every member of the legal profession, should understand that you are really responsible to some of the situation where we have in the country. It is extremely difficult to extricate the lawyers from the enablers of corrupt practices, local and international level. If you talk about the lawyers, the bankers, and the estate also valuers and realtors, this is where you have the predominant, influencers of the money laundering, illicit financial flow, and corrupt practices within the system. So I think this would give us an opportunity to see how lawyers will understand that it is not just about corruption, it's about also violation of human rights. It's a violation of our laws, and it is also the undermining the professional integrity of the association and the legal profession. I thank you very much.
Thank you very much, Larry. You know, you're a champion of anti-corruption fight, and you've raised on many issues. But I think a point of correction, because I'm also involved in terms of the body of benchers. I'm a member of body of benchers, and he's not the chairman that was involved in the solicitation. He's a person in the chambers, and the issue was around whether he can see it if someone involved in his chambers was not him directly that was accused. And then you've raised also the issue of defenders and enablers, and the sad commentary about lawyers, and in particular senior lawyers. But I think it's not just about senior lawyers. Sharp practices, which is part of corrupt practices, it's something that cuts across even junior and senior colleagues. But we just expectation is that senior colleagues should be leading right and showing the right ethical conduct. And again, that the institutions, including LPDC, will do their job to correct those anomalies. I would like to invite Dr. Martin Ejidike of United Nations, New York, who we've taken advantage of his being on mission currently here, but I want to put out a disclaimer because he has mentioned it clearly. He is appearing and speaking in his own personal capacity. And I know what that means. I've served as the United Nations Special Rapporteur on Human Trafficking myself, and usually we expect you to act in your independent capacity as an expert. Today, he's acting in his independent capacity as a scholar and as one who is part of the community. Thank you so much. You have 5 minutes. Thank you.
Thank you. Thank you so much for the introduction. I'm speaking after distinguished practitioners in the field of anti-corruption in Nigeria. So it's onerous, and it's also, I take it also as an honor to be able to do that. My discussion will focus on the international framework on anti-corruption. I mean, the previous speakers have already talked about the challenges nationally, at the national level, in relation to corruption and good governance. There is clearly a negative correlation, or what I say, an inverse relationship between corruption and good governance. When corruption increases, good governance decreases, and vice versa. These variables move in opposite directions from each other, and the correlation between them can vary drastically over time. If good governance principles and structures are not in place, this provides greater opportunity for corruption. Corruption, in turn, can prevent good governance principles and structures from being put in place or enforced. The lead speaker and other discussants have already spoken to this. I would like to focus on the global perspective. In this regard, the global legal framework. And this legal framework is provided by the UN Convention Against Corruption. The convention provides the only legally binding global anti-corruption instrument, its provisions and implementation mechanisms, and the link between corruption and the SDGs. How corruption undermines the achievement of the Sustainable Development Goals. I will look at that as well. The UN Convention Against Corruption at the moment has about 189 signatories. With this number of states, it's clearly an indication that there is a global recognition that corruption is a challenge. And not just that corruption is a challenge, there's also a global consensus on how to address corruption, hence the provisions of the convention. Critically, the convention covers 4 specific areas that might be interesting and that has been the focus of the work of its mechanisms. Basically on prevention, I think chapter 2 of the convention talks about prevention, focuses on prevention essentially. Chapter 3 on criminalization and law enforcement. Chapter 4 on international cooperation. And chapter 5 on asset recovery. The Commission has established a conference of state parties which provides guidance in terms of the implementation of its provisions. And this conference of state parties subsequently established an implementation review mechanism. This implementation review mechanism supports member states in the implementation of their obligations under the convention. This review mechanism Nigeria has been reviewed twice under this mechanism, and recommendations have been made covering the whole area of the convention. That is, in terms of preventive measures, in terms of enforcement, in terms of asset recovery and international cooperation. So basically, what do we say about corruption? What is the real challenge of corruption here? We see that corruption is a real challenge, a real threat to the realization of the Sustainable Development Goals. The whole essence of the Sustainable Development Goals is to be able to provide, development that is all-encompassing, that is sustainable. And with corruption takes away resources from the realization of the SDGs. There's been several studies on this, on how corruption has diminished the state capacity, so that nations which fail to eradicate poverty, to address hunger, or to secure the healthcare and high-quality education for their citizens, because of corruption. Of particular importance is Goal 16, SDG Goal 16, on peace, justice, and strong institutions, which aims to promote peaceful and inclusive societies for sustainable development, and to provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. Given the strong causal link between corruption and institutions that are ineffective, unaccountable, and exclusive, 3 targets of SDG 16, namely 16.4, 16.5, and 6, specifically call for reducing all forms of corruption, strengthening recovery and return of stolen assets, and developing transparent institutions. At the same time, corruption limits the realization of all SDGs in many respects, and the vast sums that are lost to corruption could have been used to improve living standards by increasing access to housing, health, education, and water. There's also been studies that demonstrate that corruption also leads to, I think Dr. Amadi mentioned that in his intervention already, that corruption leads to insecurity. I mean, we have, for instance, in Sierra Leone, the report of the Truth and Reconciliation Commission basically identified corruption as the root cause of the conflict in Sierra Leone. It was also the same in Liberia. So I'll leave it at this, and then I'll take questions.
Thank you so much. I guess just exactly 5 minutes, but I'm not surprised. One of the things UN people do very well, and I know that as the special rapporteur, is keeping time. Once you tell them they have 5 minutes, because they know the hammer will just go, and you could be cut off and you will lose interpretation. So I learned even to respond to over 50 questions within 15 minutes when I make my presentation before General Assembly. And when they say 3 minutes every state, they make sure they observe it. Thank you for keeping exactly to time. Before we just quickly open up, I would just want for us to take advantage and hear from the Executive Secretary of National Human Rights Commission, who is here personally, and one of us, a senior advocate of Nigeria, to share his thoughts quickly on corruption and nexus to enforcement, realization of human rights. And Dr. Tony Ojukwu, I want to say that for me, I think I posit that corruption is both a cause and a consequence of human rights violation. Can you please address that as you speak to us? Thank you.
Thank you very much. Corruption really is the greatest challenge I have in my work, which is the promotion and protection of human rights. If you look at the administration of justice, we talk every day about congestion of correctional centers, high number of awaiting trials. Do you know the reason? Because half of the people police will arrest is because of corrupt tendencies. They arrest people, maybe they ask you for 20 naira. If you don't give that 20 naira, they'll slam a charge on you. It's true. And you are taken to the detention. If they stay more than, 48 hours, they don't know what to do. They go and arrange with the magistrate, and they will now remand you in prison custody. And it will be come today, come tomorrow. Your case will be adjourned for another 2, 3, 4 years until the magistrate is courageous enough to say there's no evidence to prosecute you and discharge you. You may be there for another 4 or 5 years. True. Or on a weekend, they don't have money. They just come and conduct a raid around the beer parlor around your house. And they carry about 15 people from the beer parlor. If you are not able to bring 5,000 that weekend and bail us and get your freedom, by Monday you are arraigned in the magistrate court and you are remanded in prison custody. Of course, there's no evidence. Yes, they will say maybe if there was an armed robbery around that area that month, they say, okay, they have seen the people that committed the armed robbery. There's no other evidence. They take you to court. So you are remanded in prison custody. Why wouldn't the number of awaiting trial inmates be high? Because half of the people arrested are for corrupt tendencies. There will be no evidence to prosecute them, and the thing will be mounting until one day maybe there's a jail delivery by a judge or something, and those people are released. So when you see high number of awaiting trial inmates at the prison, it's because probably half of them have been brought there because somebody wanted to extort money or get something and he couldn't get it, and that is why that problem is now challenging us. That almost all the prisons, you have a prison that has capacity of 800, it's keeping 4,000 people. Are you looking at the area of, the courts? We have heard earlier on today how some clients will bring cases to lawyers, and after taking the consultation fee, they'll be asking the lawyer what of the money to settle the judge. Now, if you look at the area of good governance, we have a right to water, we have a right to health, we have a right to food, we have a right to work and all that. So, look at the kind of money we used to set up a city like Abuja. That money could have set up about 3 cities like Abuja in other places. That means those facilities you are enjoying in Abuja, you could have been enjoying 3 times those facilities. Because our contracts are very, very high compared to what it is elsewhere. If you come to Nigeria now, the International Conference Center there, I just came back from Malawi, where we had the African Bar Association. If you see their International Conference Center and compare it to our own, and Malawi is a country of less than 20 million people, which is like a state like Lagos. But their International Conference Center is better than the International Conference Center of Nigeria. What would be the reason for that? By the time you go, and I've not confirmed this, but by the time you go and check the cost of our International Conference Center, it's going to be higher than the cost of their own international conference. But they have better services. So corruption has reduced the services you get, and you can't have good governance. Are you looking at our elections? Why is our elections producing bad leaders? Because it is monetized. We use dollars to do our elections. The system, the constitution is okay, but because of corruption, we cannot apply the constitution in a way that we can get good leaders. And once the leadership is bad, the country is in trouble. You can see. Now, human rights is the greatest casualty of all this. Because as long as the administration of criminal justice is not working, as long as the infrastructure, the facilities are not working, as long as elections cannot be gotten well, all the consequences of these are human rights and lack of ability to protect them. Are you looking at insecurity? The greatest challenge of our insecurity today is corruption. Let me tell you, before, there was a team that came to Nigeria to help our law enforcement agents fight terrorism. They had an operation, but before they could get there, the thing had leaked to the people, to the Boko Haram people. What do you call that?
Insider dealing.
So it's a big challenge. What I would see more, I'm happy that the chairman of ICPC is here. Whenever I look at the systems, like if I'm going to the airport now, I go to the toll gate and I see how people are collecting money. I know that half of that money is not getting to government. I go to an office to pursue something, before maybe the contract is paid. People complain to me, this and this has happened.
If we leave you here, we're not going to...
Just 1 more minute.
Yeah.
So what I will be recommending to ICPC is I want to look forward to more of trying to study the systems and blocking easy access to corruption, easy access to corrupt tendencies, because I think it's easier to stop people from collecting our money than tracking them. And we can look at all facets of our life and see how do we, like when we are in National Electoral Commission, the option A4 system, what do we do? We just felt that in 1979, people would go to a secret booth pregnant with ballot papers. and the person can go to cast one ballot paper and he will go offloading 100 there and come out. So we said, okay, the secrecy is thumb printing in secret, but you have to come out in the open and put it in the open. So it's a matter of if we can study our systems and try to see how we can block corrupt tendencies in every facet of our life, I think it will do us a lot of good, and it will help us to save a lot of money, and then it will also help us to improve our human rights protection. Thank you very much.
Thank you. Thank you so much, yes, Leonard Senior Advocate. I will quickly go to my sister, B.A. Tom George, the chair body of vice chairpersons of Committee of Human Rights. So just give us briefly your thought. This session is kind of open for, and we'll get back to it after her. Thank you.
Thank you so very much. Prof, we're very proud of you for what you do for the human rights community, our fellow panelists, and distinguished colleagues. I'm not part of the panelists, but I've been called graciously by the chair of the Human Rights Institute to perhaps converse the importance of the vice chairpersons of all of the 128 branches of the NBA, and how, if they have been utilized, will greatly impact and change the narrative of human rights abuses in this country. A lot of questions have been asked as to what the NBA will do. The NBA can do a lot. With 128 branches of the NBA, data collection can be effective to measure, evaluate, and come up with verifiable solutions to solve our problems of human rights, of lack of obedience to the rule of law. And I want to call on the NBA to ensure that going forward, the office of the vice chairman of all of the branches is being taken seriously. If, for instance, as an association, we have it spelled out that 5% of every revenue or payment that comes into the coffers of the association will be used to promote, to prevent, and to fight for human rights abuses. I believe that some of the issues about bad governance, about corruption that we're talking about today would have been reduced. Now, I give you a very practical example. I had the privilege to speak to about 50 ballets in Lagos here. And what was my challenge? I talked about having an engagement protocol at that level to be able to have a direction, have constraints, responsibilities, and obligations to manage their affairs. Now imagine that the NBA could take up such a responsibility to go to communities using the Human Rights Committee manned by the vice chairpersons to go into communities, provide engagement protocols that will ensure the respect for human rights and obedience to the rule of law. I believe that the narration would have been different.
Thank you.
And so I want to urge everyone, as I was walking in here, someone told me, do you people have a body of vice chairpersons? What does that mean? You guys don't have powers. And I responded by saying, it is not about powers. It is about service and responsibility. We need to begin to change our orientation and mindset. Thank you.
Thank you so much. Thank you. Thank you. It's time for Q&A. There is a lot to be said, but it's important that we give the audience an opportunity to also ask questions. First questions, we'll prefer direct questions. And we have also some questions for the panelists. I want to recognize the council members members of the Human Rights Institute Council members here present. I can see the Secretary, Mr. Victor. You're all welcome to this, and then other senior advocates of Nigeria and the members of the executives of bar across the 128 branches, you all recognized. Please, if you have a question, and then I can see quite a number of my colleagues from University of Nigeria, Faculty of Law, well, you're all welcome. Please, if you have a question, raise your hand. We hope to take from all of the sides. I can see you one. Who will help with the mic? Because you need to speak to the mic in order for those who are online to hear it. I'll take like 4. I can see 2 hands. Then she, okay. No, I've not seen a lady. He said 2 hands. I've seen the 2 hands down there. Please, can you come over here? Probably. It will enable us to quickly engage. Please keep it short and just question at this point. Yes, thank you. Please come out if you have question, please. Let's just take all together. No, he's helping. No, he was just trying to help. Thank you. Yes, introduce yourself. Is it not working? Please, just give him mic that is working. Can someone help? Thank you. That one is not working. Just pick another one.
All right. Good afternoon, distinguished panelists.
Yes.
Distinguished Leonard Silk. My name is Chinon Songwoye. I'm from Abuja, Unity Bar. So my question is very simple and straightforward. From everything that has been said, I want to know if it is possible for us to get to a point where we hold people to account in terms of their own responsibilities. Because if we just keep saying corruption, I don't know, I'm thinking, for instance, I understand that ACTA creates a responsibility for magistrates to carry out routine visits to police cells. I mean, that can be a move to hold you to account based on that. That's just my...
Thank you for being direct. Next person, thank you. Quickly. Yes, you can come out, just to save time. Come and join. You'll be the next after him. Go ahead.
Good afternoon, distinguished panelists. My name is Justus Uche Ijoma from Onitsha branch. My question borders on levying execution on human rights, judgments of courts relating to human rights. Personally, my engagement as a human rights defender, I have found that going to court to get judgment against duty bearers like the police, the DSS, the army, those government agencies, state actors, is not so much of a problem. Sometimes the court could give judgment, pay this person XYZ amount of money. But taking benefit of that judgment as to enforcing that judgment against the police is a Herculean task. Everybody who has engaged with the system here will attest to this fact.
Thank you. What's your question because of time?
Okay.
Yeah.
So the question is, what is the institute going to do to ensure that the process of enforcing the judgment... Is
corruption implicated? Because we are not just dealing with... You remember the topic or the thematic focus of this discussion? Corruption, how corruption fuels insecurity and bad governance. And we're also looking at the nexus with human rights. But you're talking totally about enforcement of corruption.
Yeah.
You think there is corruption that is related to that. So just because of time, if we can keep focus.
Most definitely, it's linked to corruption.
Okay.
Because if it's not, corruption that inhibits the process of enforcing court's judgment, it will be seamless because the laws are there.
Yeah. Thank you. Thank you so much. Yes, you will be the final one, unless there is a lady who wants to speak. Any lady? Oh, yes. Is that? No, you're a man too. I was thinking of a lady to give. Please go ahead. Can you give him the mic? here who
Thank
was
you.
raising. Go ahead.
My question, number one.
Introduce yourself.
Oh, sorry. Chris Ezeibe is my name. I practice at Uyo, Akwa Ibom State.
Thank you.
We know it is more expensive to run around persons who are suspected of corruption, whether politically exposed or corporate governance and all of that. Can't we devise a method by which we plug have it, you can't spend it. I was somewhere outside these climbs and I bought something and I presented $200 bill and they were looking at me like a rogue because it is terrible there to hold such amount of cash. So must we be running around persons who are suspected of having committed corrupt practices instead of plugging the holes? Number two, must there be corruption? Must there be petition before we can chase around the monkeys, the termites, and all the animals that are eating money before appropriate agencies must take steps? Thank you, Madam.
Thank you so much. That's a very important question. It's on around our values, and we hope ICPC can take it up. I guess now we have to. Who? I think there was a gentleman here. Please, just quickly, please. We'll end it. Are you waiting for? Oh, yes. I didn't know. I thought you were helping out.
No.
So go ahead.
Yes, Professor Benga Odunton, University of Kent, and Liberty Semper Fidelis.
Introduce yourself, please.
That's exactly what I'm doing. Benga Odunton, University of Kent, and practicing also Liberty Semper Fidelis Chambers in Ikeja, Lagos. I'm quite pleased with the attitude displayed by the chair of the ICPC when he was departing from the podium. He said, if by this time next year nothing is being done to show that there is some commitment by the NBA itself to the corruption issue, don't call me next year. I know he was speaking tongue-in-cheek, but there is precisely the duty on us as the NBA, and this is going to be framed as a question right now. How can we be talking about corruption in government or talking about corruption in all the other sectors we are talking, when we ourselves as lawyers may still have to be paying bribes to clerks
every day
within the court system
every day
on a systematic basis? How do we solve this? If we don't solve this, don't call us next year to talk about corruption in society.
Exactly. Thank you so much. That's quite poignant. Yes, finally. Good.
Good afternoon, learned colleagues and the panelists. I'm Charles Ukebu from Port Harcourt branch. So my address or speech seem to link to the last speaker. From my experience in this bar, I seem to see that even the MBA executive, they are fundamentally corrupt. So I begin to wonder how we can be corrupt here in our house and go outside there chasing corrupt persons. For example, if you look at the attendance this time, more than 90% of those of them who attended did not have bag, for example. And that is corruption playing itself out in the whole system. I mean, in our system here. Then how can we, the panel, I want you to address us, how we can be corrupt here and we seem to pretend and go outside here to fight corruption.
Thank you.
Thank you very much.
Yeah, your point has been made. And that's back to the point whether people have come to query and they need to establish that scientifically, whether in our DNA there is corruption, whether there is a corrupt gene in our DNA that is fueling corruption in Nigeria. And it's a conversation for another day. I would like to give the panelists, including the late speaker still online, I hope, opportunity to round up by making a concluding statement. But I would like us to also, the panelists, think about us the following question. We all know that insecurity and corruption exists, and today's insecurity may be a symptom, in fact, of decades of corruption and misrule that have taken away resources. Even pensioners, you see a person put in charge of pension fund, stealing billions, and weak prosecutions, the prosecution system is weak, and they will go away with it. There is plea bargain, compounding offenses, and lawyers will get their money. So they must, of course, represent, including the bad guys. But does that make you to cease to be a minister in the temple of justice? We have to uphold ethics in all we do. There is a system I saw doing research in Nigeria and Mali, what they call, and in fact it's common with the Francophone, they call it budget court, and it's actually a branch of the Supreme Court. When what the ICPC chair told us, they try to be proactive, analyze budget, look at certain things, query, and stop the money from being disbursed. Here, for any project that money has been spent, they will come before the budget court, they will look at the expenditure, and when you're training in law school, those who will pursue that aspect are also exposed to accounting, and they work with a team of qualified accountants. And they will look and justify that project, that money was spent. I thought that was a brilliant idea. And whether we should not look at also that budget court being an aspect, because when you look at it in terms of oversight, you will see that the legislative oversight on executive expenditure, but not much judicial oversight on executive expenditure. That we may also toe that line in terms of making a progress. I would like to hear you look at innovations, how to fight corruption using technology. I believe that probably every human being have a DNA of corruption in their, but how it manifests depends on the system and the culture. Because if you look abroad, there is little opportunity for you to be corrupt, because the system, payment, everything is tracked electronically, and the way it's organized, it doesn't allow for much corruption. But in our own system, it appears we encourage that. People have bought CCTV, even for Abuja, years back, and they bought what was second-hand, never worked, and billions of naira or dollars were spent in that. And nobody had been held accountable. Every day you see those kind of things, and insider trading, and with bandits, with insecurity, you see how corruption implicates even security, people that are supposed to maintain law and order being part of that. Please look at that, look at what we can do, possible solutions in order to change the narrative and begin to imbibe the culture that anti-corruption. So I will probably want the last to be the first in responding, the last speaker on the panel, and that's Dr. Martin. You have 1 minute. Oh, you have a mic. Yeah, thank you. Look at this one. Yeah, thank you. So I can stop you with this.
I think I will, of course, talk based on the global experience. I think that there's nothing in the Nigerian DNA that makes every Nigerian corrupt. There is nothing in the Nigerian DNA that makes every Nigerian corrupt. There's no difference between a Nigerian and any other person elsewhere. The only difference is how we implement our laws. That is the difference. There is no accountability. The essence of law is to deter certain behavior. So if the law is there and the law is not being implemented, if Mr. A could take 20 billion, or I don't know how many billion someone took from the pension fund, and is working free, nothing stops Mr. B from trying it. So that's what's important. So what I want us to go away with here is the importance of accountability and the role of lawyers in ensuring accountability. And I think that the chairman of the ITPC also mentioned something like that about lawyers also being involved in criminal activity. So these are things that you need to look into that I consider very important. Thank you.
All right, thank you. Can we get concluding statement from Dr. Sam Amadi? Is he online? And also Larry Owaju, if they're online, they can give us their final thoughts and respond to the questions that have been raised. Thank you.
Can I go on? Okay.
Go ahead.
Okay. Okay, thank you very much. I think very good conversations and points raised. Let me respond to my Oga, the professor, the head of ICPC. Truly, ICPC has been very, almost excellent under its leadership. They have brought intelligence, of course, integrity to criminal prosecution. And it's correct that they are involved in a lot, much more than just prosecution. But generally, the focus, not just Nigeria, the focus of anti-corruption, driving from historical background and the legalism that we see in even legal practice has been to emphasize prosecution. The second point I want to make, and by the way, you need prosecution to reinforce incentives and create what we call credible signaling to citizens and office holders that these norms and these rules mean something. So you can't rule out prosecution, but it should be a part of a strategy that it's focused on engendering collective action, creating principles of reciprocity, and committing people to understand that the new ways of doing things better have reward, political and economic. Now, we talk about the consequence of corruption, especially in terms of revenue loss. I'm more concerned with what happens to state as an institution. So apart from money, we lose billions. But actually, we lose the capacity both for law and order. You can't really have real law and order in a corrupt society. So my focus would be that we always think in terms of how corruption destroys the effectiveness of the state, in terms of the norms, in terms of the autonomy to make rational decisions. The state, as Max Weber talked about it, as that which controls monopoly of violence and is rationalistic in terms of the rules. In fact, it's the beginning of the bureaucracy as a law-making and law-stabilizing process. So if the state is corrupt, endemic like in Nigeria, then it ceases to be a state in the Weberian sense. And finally, the corruption destroys the prospect of economic development, not just the resources you have. So in the long term, you don't have capacity for economic transactions. Contracts become open-ended and incomplete, what economists call incomplete contracts. So they really don't, there are too many risks that a contract becomes really not an instrument to commit investment because the contracts themselves are open-ended. Too many, it can't be sure. We could say contract XYZ. There are a lot of contingencies that corruption creates that make those contracts not binding, not even reliable as instrument for economic transaction. And I would like to say that lawyers have to really, NBA, the self-regulation, the regulation of the law practice should move away from just the way we've done. We should be strong enough in a way that lawyers who aid through legal advisory or other form of corruption and gross public negligence and incompetence should be penalized. That's really where I think if you create a penalty process whereby either they are struck out of the rules or they lose privileges or they are punished, much more, not just financially, but with some kind of naming and shaming. Yeah. And then you create a new index for good performance. Then you incent new behavior, new professionalism. Professionalism is not a rhetoric. You have to create structure, certain structure.
Thank you.
To engender professionalism. Thank you.
Thank you, Dr. Sam Amadi. Thank you, and for actually staying on for the entire process. We appreciate. Can we quickly also have Mr. Larry Owaju? Is he still online, please?
Yes, still very much available here. Thank you, Prof.
Just take
Can
a
you hear me?
minute to give us a concluding statement. Yes, thank you.
Thanks. In conclusion, I think it would be very important that we have this resolution living here, that we're not going to be back to where we were. And then also we're going to move forward as an association to ensure that we not only just reinvigorate the role of the MBA, but also as all lawyers, that we want to actually commit to the repositioning of the integrity of the professional association that we have, and also the profession that we all profess, and commit to also uphold its integrity. And for that reason, we must not just wait for the external forces to criticize the sharp practices or abuse of the ethics of the profession, but that we all as lawyers must take it as a responsibility to ensure that we stand up to criticize and also pursue those that are found to have denigrated the profession. Quite a number of them abound. Like I mentioned, of those lawyers that are there, quite a number of them constituting, club to the successful prosecution of corrupt cases. And like we said, corruption fuels not just insecurity. It also helps with the poverty situation that we're talking about. It undermines the rule of law and creates, the insecurity for all of us. And we can't afford to pretend that lawyers are not just there to play this role. We must separate the professional responsibility from the conspiracy that some of the lawyers have attempted to blend the two, disguising and pretending to be discharging their professional duty, whereas deep down they know that that was not the case. The case is usually an attempt at assisting those who have violated the law to escape from justice. The social engineering of the society lies with the lawyers, and that is why the profession is there to assist in upholding the rule of law. You can defend your client to the extent of ensuring that justice is still done to the system. Imagine the cost that the law enforcement agencies commit to investigating cases and also prosecuting them, only for lawyers to not only attempt at deploying technicalities, but even going to the extent of compromising judges, to have those who are really guilty of abusing their office to escape justice system. And the country is looking up to the MBAs, looking up to the legal profession to have a redress in the situation that we found ourselves. And we must also, as lawyers, monitor our judges and the bench to ensure that the NJC is living up to its responsibilities and judges are upright.
Thank you so much. You've said so much, especially reinforcing, importantly, the critical role of lawyers. What we expected of as vanguards and defenders, we are not above board, and we should be promoting those anti-corruption values. I will come finally to Professor Bolaji Owasoye, Senior Advocate of Nigeria and the Chairman of ICPC, to share his final thoughts and also respond to the questions that we got from the audience. So you have double task here. Maybe you start with responding to the questions. Thank you so much. Yeah.
Thank you very much, moderator, Prof. Somebody asked whether or not we can hold people to account and gave a very interesting example of, for example, the ACJ asking magistrates to evaluate holdings within custodial facilities. Just in Lagos a few weeks ago, magistrates, in response to that provision, tried to evaluate some police custodial facilities for holdings. And they were sent back, in fact, virtually threatened. And of course, the matter was publicized and all that. Nothing has happened till now. Now, if the people who are to take responsibility and provide the political will for the kinds of reforms that are required, if they're unwilling to do it, you will keep having these pockets of examples that I've given, and they are very discouraging. And until push comes to shove, this is the kind of thing, for example, that the NBA ought to champion. To say you cannot do that. This is what the law says. We are trying to follow the law. And one policeman somewhere resisted, a DPO resisted, and nothing has happened. So until we have some of those responses, I'm not sure that we'll get the kind of result that we want. Somebody also said that when they get judgment against law enforcement agencies and duty bearers, they can't enforce. Well, because you are taking an easy way out. For example, there are many reasons why law enforcement, I'm not trying to defend the inadequacies of law enforcement and anti-corruption agencies. We have our own weaknesses internally. Poor investigation sometimes, poor prosecution sometimes. Inadequate facilities to do what we're supposed to do efficiently and effectively. And so and it's been said in this panel, corruption weakens the ability of government to deliver. It's a catch-22 situation. We find out that those who have caused that situation are better resourced than the state. They are much more resourced than the state. But how do we reverse the trend? Again, I would say there must be the evidence. There must be willingness to challenge that status quo. That's why bold transition is important and remains important. But when you then get a judgment, if already I'm struggling to provide infrastructure that my office is there, you go and get one judgment of 5 million or 10 million, who is going to pay you? I'm not going to pay you. You can get the money anyhow. Because one of the reasons that the challenges that I'm facing probably happen is because of under-resourcing and the weight of the challenges that I have to carry. That's just the reality. I'm being very practical and very frank. But that is not to say that we should not make effort, and I'm going to talk about some of the efforts that we've made. Somebody said, how can we restrict access of public servants to money? And that must there be petitions before anti-corruption agencies? No. Anti-corruption agencies do not depend on petitions before they take action. We have intelligence-led investigations, quite a lot of it. It's just that people think that when there's any action, it's because you have received a petition. 3/4 of the petitions that we receive, we do not action. They are misguided, they are exaggerated, they cannot be backed up with facts, they are orchestrated. They are just parked somewhere. But we are forced to still look at them because you don't want to throw away the baby with the bathwater. And sometimes you get a petition, you don't look at it, you are missing out on something big. And you spend money on some of these red herrings. So those are some. Occasionally, we feel minded to go after those who send those false petitions for lying to, and we have provisions under our law to deal with that. If you lie or mislead an anti-corruption agency. Because before we discover it, somebody might have been hurt and we would have spent a lot of money and all that. But these are some of the challenges that we face. So the answer is not only petition-led investigation. Well, there are NBA officers here, so I'm not going to speak for the comment about the NBA needing to purge itself first, as said by the gentleman. Victor is here. Chinoye is here. There are those who are in charge of the panel who are here. But I think that the NBA has showed some promise. We need to take that promise forward. The truth of the matter is that there will be no change whatsoever until lawyers get their act together. And it must not be based on self-interest. All of the conventions, international conventions, changes in the law that you see about reforms, who drives them? It's lawyers. It's lawyers. Some of the landmark decisions globally that have changed the world are public interest litigation. Nobody got paid for it. And Professor Oduto made it as if he read my note. Because the moderator asked me to come and sit down, I didn't get there. Lawyers pay bribes to file papers, and they don't complain. Every minute, you pay bribes in the courts. You don't complain. How will corruption thrive? when my people come to me and says one registrar is resisting, I say, can you just arrest the person? Yes, now. Because if you have the audacity to try and extract a bribe from us, that's why I was talking about ethical fault lines. Whether people don't know where to draw the line. Every day lawyers pay bribe within the court system. And it's not just young lawyers who feel frustrated who have to pay. Senior lawyers pay. You pay to get records, you pay to file, you pay to get your receipt, and nobody's, and we are lawyers. And we are 13,000 in this conference. How can anything change? Lawyers can go to the court and demand that this person must be sanctioned. Lawyers can think, lawyers can arrange and say, look, anybody in this place, one of the reasons I left practice was because a judge asked me to serve as pointer to a belief. I said to him, we've paid filing fees. I was very young. This was 1986. I said, my lord, you should ask why he did not serve. After I paid filing fee. It's his job to serve. He knows Lagos. He said, you this young boy, come here, come here. When were you called to the bar? I said, just last time, my lord. He awarded 1,000 Naira cost against me. When I told my principal in the chambers, he shouted, 1986, 1,000 Naira cost against my client. He said, Bolaji, what did you do? I told him, I knew I would always fight with the court because I would not do it. So I just went into academics. That's a safer distance. That's just it. But those things have not changed. It used to be that in the company's registry, which used to be at Oil Mill Street in Lagos, when you go there to look for a file, you will see mountains of files on the floor, reaching the ceiling. Only people who can pay will be able to conduct a search on any company. It did not change until one senior lawyer, I will not mention his name, he's late now, wrote a letter and said this is unacceptable. The very next week, they moved them from there to Ebutemeta, reorganized the place because a lawyer dared to speak. That is the kind of respect and courage and importance that lawyers have in society. But we are trading it off for paying 10 Naira, 1,000 Naira, 100 Naira, 5 Naira. I used to run an NGO before I got into government. I gave free legal services to widows and helped them to apply for administration, letters of administration. So we had to get letters from Lagos High Court. And they asked my officer for bribe, my staff, my assistant. I said that she should go back, record the guy, prepare to offer, take pictures of the place. And then after she did everything, I then wrote a letter to Justice Phillips. Justice Phillips is alive. She was CJ. I took pictures of the registry where the files were all over the floor. I said, well, there are two things I have to ask. The first is that you must deal with this guy. The second is that if I'm a registrar in this place, I will be tempted to collect bribe as well. The very next week, and you can quote me, the very next week, the registry was reorganized in Ikeja. Justice Phillips was CJ. And the fellow came to my office prostrating, rolling on the floor. I told Justice Oyewole, who was probate judge, I said, you have to, he called the guy immediately. Everything changed in that place. When they hear the name of my office, the file is appearing from anywhere. But I know it is eye service. But there shouldn't be only one such example. There should be many more. Every lawyer should, whether you are 1 year old, 1 day old lawyer, you have a duty, it's dignity. You say, I cannot. I went to school, burned the midnight oil. I'm not saying registrars are not important people. You cannot ask me to. So until lawyers choose to challenge some of these things, I'm afraid nothing will change. A footnote to respond to your questions, Joy. Sorry.
Yeah.
You said, you gave a lot of suggestions about things that we should do, including being proactive. One is that the example you cited, I don't know from which country. Since 2019, for example, we have something called Constituency and Executive Project Tracking Group. Once the budget has been passed, whether it is good budget or bad budget, it is the law. And we are bound to implement the law. If the budget is appropriated that you should build a road in any community in Nigeria, a school or a hospital, and it's one of the projects we've picked, we will go there, call all the contractors, the person who's put the project there, why is the road not built? The money was released. Where is the money? If the contractor started the project, we make sure that you finish. If you finished and inflated, we collected the change from you. And we have records. It's even on my phone. After this panel, I'll show you. Now, some people will say, I've got colleagues from the bar who say, Prof, why don't you prosecute them? So I asked them, good, we can prosecute them, but what does the community want? To see the road done, to see the school built, to see the hospital built, or to see the criminal in jail? We don't collect the money. He comes out a few years and he will still become easy. Which one do you want? So I think there are models that we can learn from and that we are struggling to implement. The moderator also mentioned the role of technology. I agree absolutely. Next week on the 4th, some of you would have seen advert, we're doing a hackathon with NITDA on how we can use technology to stem IFFs. As at yesterday, the message I got was that we had over 2,000 entries. The selection is going to be done next week. NITDA and some experts in using technology, we're going to model and profile about shortly 7 and then do trial runs of this sort of thing that we're talking about. How can it help us? Because it is easier to stop the money from taking flight than to start pursuing the money after it is taking flight. After the money has gone, it's much more difficult to catch it. Finally, Professor Sam Amadi mentioned, and I agree with him, about behavior change. We have a project on behavior change. Just as I've said, we are trying to look at a whole range of initiatives beyond law and order alone. But you need both, because if you don't have the sword of Damocles of the threat of prosecution and imprisonment, some people will never repent. So you need that alongside looking at what is triggering and allowing this to happen. That's why we, for example, will take the budget, take about 3 months, analyze all the projects, and write to the minister. You cannot release money for all this until we know what is going on. And it's working and saving the government quite a lot of money. People already know another. And the final example I will give, people who are aspiring for some top position in the public service, they get sent to us for profiling. After much push, we said, let's profile them. We profile them and we will say, this person you can't appoint. We'll put you on polygraph and some other things. It's voluntary. If you don't agree, that is a statement on its own. If you agree and we find something, if you push, what you buried that the leg is showing, we will exhume it. And the report will be sent. So now we find people who say, I don't want to be director in this place. I don't want to be permanent secretary. Because when ICPC starts digging, so ultimately what that means is that some credible kinds of persons will assume those positions who necessarily do not have baggage. Hopefully it will take time before we reach a critical mass, but the journey of 1,000 miles starts with a step. Thank you very much.
Excellent. That's important. We're ending on a very high note. Thank you, Professor Bolaji Owasonye, SAN, and the chairman of ICPC. A lot is really going on. I think we've had a very fascinating session. And you've been able to respond to all the questions, and we've got concluding statement from the speakers. Now we will go to the closing ceremony, and there is an announcement from, I think, is it Fumi Adogu, council member of NHI, with regard to conference materials. If you're around, you can come up and make just the announcement. We don't have much time already, we're out of time. And I want to call quickly on Mr. Victor Wakase, who is the secretary of the NBA Human Rights Institute, that will give the vote of thanks. You will give the vote of thanks, and I hope you remember to thank our funder, the organization that have supported this session, amongst others. Thank you.
Thank you very much. Permit me to stand on the existing protocol. We have an information on the collection of conference materials. It is right now going on at OD. That is the starting point. Thereafter, you will move to BWC. We had an itch because the materials supplied, the bags supplied were substandard. So we had to return them. I'm speaking because I'm a member of LOC. And I don't want us to see our national officers as being corrupt. Please, they are not corrupt. They are upright people. Thank you very much.
Thank you. Thank you, Fumi. I think it's also to explain further the issue raised about, so there is no bag corruption at least. So you can still have your bags. You put your name down, and then at Best Western Hotel, they are giving bags. That's for your information. Thank you so much, members of the Nigerian Bar Association, for participating in this session. I chose to thank you because you cannot have behavioral change without people listening. You cannot have change without people facing or people taking it or undertaking to be changed. So your participation here is already an indication of what we seek to do, that people must be interested in the issues, in the concept, in the entire problem that relates to corruption in Nigeria. There is nothing more to say. I want to thank our sponsors, MacArthur Foundation, for sponsoring this event. It's a sponsorship deal. We want to thank them. I know we will still have more work to do with them. I want to thank the Executive Secretary of National Human Rights Commission, Professor Tony Leonard Silk. We have to work together. I think we had a chat. I was privileged to be there with the chairman when you were having the chat about how the Institute can cooperate with the National Human Rights Commission to take these issues further. I want to also thank Mr. Martin Ejidike. In less than 2 months, you have spoken to us twice. I think I'm right, ma. We want to thank you so much. That's the kind of cooperation we seek. The Institute is new in the sense in approach about what to do. And we want all partners on board to take this further. I want to thank Professor Wasonye, Pioneer Council member of SPIDEL. That is the connection. You know, he said he left practice because academic, seemed a fair distance. But he has been with us. He's still talking about these issues. He's still talking about his pains, about how the society is not going the way it should. So he's still in practice, Prof. Prof, you're still in practice. And I think federal government has made you our #1 anti-corruption practitioner, and there's no two ways about it. We want to thank Mrs. Abietam George, who in Lagos branch has helped develop the framework for pro bono service. I think it's simple. Let the corrupt individuals be arrested. NBA will offer them pro bono services to make sure that their fundamental rights are not violated. I think it's as simple as that. So we have to develop a strong pro bono framework, which means that, everybody will have his day. Everybody will have a fair hearing, but let people be responsible in their actions. I want to appreciate also my chairman, the chairman of Human Rights Institute of the Nigerian Bar Association, Mr. Chino Obiago, Leonard Silk. We want to appreciate you for your steadfastness as this is taken. The Institute is new, is brand new. We know your passion, we know your contacts, we know your network. We know what you can do. I think it is time for action, really. When you talk about NBA taking critical, steps in addressing some of the issues. I am glad that Professor Wosoye talked about NBA has shown promise. I think it's now about taking it further. I want to thank our 2 speakers. I reserve the best for our foreign delegates and out-of-station speakers. Dr. Sam Amadi needs no introduction in Nigeria as far as the issue of social justice and development is concerned. He's the person you would like to listen to. He's the person who is always available. Dr. Amadi is the only person who is available at all times. And I think it has to do with passion. If he's not going to be here physically, he will tell you, I will make time and attend to you virtually. That's who Dr. Amadi is, and he has just delivered another masterpiece for us. Thank you, Doctor. I also want to thank Dr. Suraj. When we become expert, Ms. Abakoba, who taught me, said, you move in the cadres. At the level he is in anti-corruption work, I think he's a professor. And that takes me to the professor, Mrs. Ngozi Ezelo. We appreciate you. It's always a delight to be with you. It's always a delight to hear with you. Rather unfortunate for me that I didn't come to University of Nigeria, but now I have a lot of dealings with you. And as a member of Council of the Human Rights Institute, I think my own session has started. Thank you so much. We have presentation of gifts to the panelists who are here. As you know, we have co-opted panelists. So what we are going to do is to invite the chairman of National Human Rights Commission, who offered to be on this panel, who agreed to be on this panel to do the presentation of the awards to our distinguished speakers. Professor Jukus. Please, can we? Oh, okay. No, it's in order. Okay. We have presentations to be made. We recognize the presence of Justice Bello of the ICPC, former judge of the Federal High Court. Please, a round of applause for him. Thank you so much. Please, just. Thank you so much. Thank you. Ma, you don't know if it's a box of dollars. Yes. I would like to invite you, sir, to receive your present. Yeah, Dr. Martin Ejidike of the UN. I am taking the liberty to invite Honorable Justice Bello, former judge of the Federal High Court, Federal Commissioner, ICPC, to present the award to the chairman of ICPC. Yes, please, the speakers, Dr. Amadi's present will be couriered to him, and Professor Larry Waju Suraj. You will receive yours. We can send it virtually. We'll take a good snap, but we are sure that you will receive it. My Lord, please, we need a group photograph, please. You can come up.
Wow. Okay.
Okay, you want us to come down. Yeah, thank you, Abietam Judge. The work continues. The technical advisor to the Institute. He's not here present, but he worked assiduously for this purpose. I thank all members of Nigerian Bar Association who are here. Thank you very much. And enjoy the rest of the conference. The coordinators have an announcement to make, please. I would also like to invite Mr. P.C. Gwedibie, legal advisor of ICPC, to join in the group photograph.
Sorry, there's an announcement for everybody. Please note that there will be a showcase session at the main plenary hall, which will be the launch of the NBA digital app by the NBA president. It's going on at the plenary hall right now. So we may move there for the launch of the NBA digital app.